All right. Hi, everyone. Hi. Good. How's everyone doing? Thank you. Did any of you come last hour? I saw a couple of you there. For those of you who missed it, we had our Constitution Day celebration. Tell us about it. Was it good? You like it? Yeah? Tell us what happened. For your classmates who couldn't stop by.
There was free Jimmy Johns.
Definitely the highlight.
And then Fifth Circuit Judge Jennifer Elrod was there.
She was there.
Had a Q&A between Professor Blackman and Judge Elrod. Talking about the Constitution.
It was a lot of fun. And because you didn't come, you didn't get free constitutions. You missed the best part. Did you take a constitution?
I've already got one.
You can never have enough. You keep one in each suit jacket. Hey, Zoe. Well, what's interesting is there's actually a federal law that requires all higher institutions that receive federal money to put on a Constitution Day celebration every year. And to my knowledge, the school's never done it before. So now we're doing it. You seem perplexed, but yes. Yes. You'll study in common law about unfunded mandates where the governor says, okay, you don't have to do this, but if you don't do it, you won't get any money. And there are lots of those conditions placed on. So one of the conditions which is to do a Constitution Day. Yes, Joey?
This is only private institutions versus state schools?
All institutions that receive any federal money?
I'm confused because my undergrad college, I would check their events all the time, and they never had anything like that.
A lot of schools don't comply with the law, Zoe. It's tragic. And all the holidays to ignore. They ignore Constitution Day, which is the worst. Next year. Okay. You can organize it. See, don't volunteer. All right, any questions on deeds, on titles, on contracts? Anything on your minds? Anything? Okay, today our goal is to discuss recording systems, okay? Very often we've heard in various questions, someone said, the deed wasn't recorded, I think I told you, don't worry about that. We'll get to that in a few weeks. Well, today, my friends, is that time. We'll be talking about recording. And one of the places where you may have heard about recording is when we discuss color of title. Okay, color of title. Let's start down there. Stephanie? Remember what color of title is? Oh, come on, that was like 2 weeks ago. No, don't Google it. I swear, I once had a student give me Wikipedia in class. Don't give me Wikipedia. That's not an answer in law school. You're adults now. Use Westlaw or Black's Law Dictionary. Rebecca, do you remember what?
Not on Google.
Good. What's color of title?
It's the claim founded on a written instrument or judgment or decree that's first and later defective.
Good. What was the context where you studied color of title? Do you remember where that came up in play? God, this is like 2 weeks ago. This is not that long ago. We've been in class. This is our 8th class. Who remembers? Anyone? Yeah.
Adverse possession.
Why does color of title matter in adverse possession?
Some people will come in with a fraudulent title, and they look at it as sort of a sign of at least that person thought that they owned the land.
Okay, good. So the thing about color of title is if you have, remember Mr. Robinson was filling out the affidavit of adverse possession? It didn't mean a damn thing, but he had some sort of paperwork showing a paper trail, right? The color of title doesn't just mean a piece of fraudulent paper. It can. If you have, for example, a deed that was never recorded, you never recorded your deed, no one else knows that you owned it. So the recording process actually feeds into this adverse possession claim. So let's talk a little bit about recording as well. The reason why we have recording statutes is so that people are on notice who owns what. You might imagine that's very difficult if you're buying a piece of land to try to figure out, hey, is this guy selling to me? Does he actually own it? That's a very tough question because usually we assume in property that the person's lying, and whatever they're trying to sell you, they don't actually own. They're lying about it. Okay? So to solve that problem, governments, usually at the state and county level, created these indexes, these huge books. You can see how big it is from this picture. These huge books which record every single land transaction. who sold it, who bought it, who put a mortgage on it, who put a ring on it, etc. Every single transaction, if you're paying attention, every single transaction is recorded, okay? And the way it's recorded generally is a couple different ways, but the most important piece of information is, you know, who's giving it, who's receiving it, what's the description of land. And the purpose of these books is to make sure that anyone can come back later and check what is the chain of title, right? What is the path by which the property owner today got it from the previous property owner? All right? Any questions? We get too deep into this. Okay. So before we get too far, I want to clarify one concept which you probably studied before, but maybe not in this context. Right? We'll go back to Rebecca. Rebecca, if I transfer you a piece of land, right? I sell it to you, between the two of us. You never record it, right? I sell it to you. I give you a deed. You never record the deed. You never bring it to the county office. They don't write into the book. Between the two of us, who owns it?
I do.
How come?
Because it's valid between the two of us.
Explain that.
I don't know why. I don't remember why. I just know that it is.
Okay, you're right. Eric, do you want to explain why it's valid between the two of us only? I'm not giving you a choice. Would you please? Please. We're in the South, right? Please. Bless your heart. That's the other one I love.
Well, you know, I gotta hold you to that consistency.
Is it acknowledgement?
Let's put it this way. When I sold it to Rebecca, right? Who are the two parties involved?
You,
Is there any third party involved?
no.
Okay. Between the two of us, is there any dispute about what happened? Right. If, say, for example, I sell to Rebecca today and tomorrow I go to court and say, no, I never did that. She'd come to court and show the deed, right? There'd be no dispute. She'd win in a heartbeat. Okay? But now let's imagine a different situation, right? I sold it to Rebecca and then Rebecca sold it to Eric, right? Now there are three parties involved. If Rebecca never recorded her deed, what proof is there that Rebecca could sell it to Eric?
There is no title.
None. So the first thing to realize is that as between the buyer and the seller, you don't need to record anything. Recording only comes into play when you're dealing with a third party. Recording only matters when there's a third party. Virtually every case we'll do this semester with recording involves facts where someone sold to someone else, and that person sold to a third person, and then there was a fourth person, and there wasn't recording done. That's where the problem arises. Everyone with me? We'll get that. All right, so let's review some terms, okay? Grantor, grantee. We did this last week. I'll give you a hint. Artemio, tell me, who's the grantor and who's the grantee?
Grantor is the one that gives.
Good.
And grantee is the deeds.
Good. And how do you remember that? What's that little device I told you? No, device?
The OR.
Do the other one first.
Me?
Me, exactly. Right? Remember, me, EE, that's when receiving it. Anyone else get the role? Everyone get it? Thank you. Thank you for passing it. My first class, there's something of a, maybe it's a concerted effort with people in this side of the room never get it. And I think it might be deliberate, but I don't know. The people in that corner have not once gotten the role. Okay. So the grantor is giving, and the grantee is receiving. This is very important to keep in mind, because when you're trying to trace title, you're interested in two parties, the giver and the receiver, or the grantor and the grantee. The way these books are indexed, and I know you can't see that, but it says over here grantee, it says over grantor, this says kind of deed, date of deed. Okay. So before we get to this, there are two main types of indexes. Okay, the first one's called a tract index. Okay, a tract index. These are fairly rare. right? The reason why they're rare is that a city has first divide up every parcel of land into a tract. Most places have never done this. Most places have deeds going back hundreds of years before these tracts ever existed. So for the most part, we'll be dealing with what's called a grantor-grantee index. Okay? These are two separate books, index. Okay? There's a grantor book, and there's a grantee book. These are separate books that are kept separately. The reason why they're kept separately is because you trace title from the most recent event. If someone's selling you a piece of land, you need to make sure that they actually received it. In order to make sure the person selling to you received it, let's see, Zoe. In order to make sure the person selling to you received it, which book did you get out to check? Think about it.
I'd say, if you're looking at a mortgage, I'd say you'd be looking at grantor books since you'd be granting the mortgage.
We're not talking about mortgages here.
Oh, I mean,
Wouldn't matter.
If you're looking at the grantee book, you really need to make sure you bought it.
Exactly. This is actually a slight tricky point I want to stay on for a second. The person selling it to you, right? He's your grantor, but that's not what you're worried about. You're worried about when did he get it. When was your seller a grantee, right? How did the person selling it to you get it? You find that in the grantee index. And I want to do an example that's in the book that walks you through this very carefully. So to start, I'll put these in the correct order if I remember to do it before. You start with the grantee index, and then you go to the grantor. So if you turn to page 670? 648, I'm sorry, 648. And I want to walk through this very slowly. Everyone see it begins, the paragraph says, assume that a man named Dubeck. Okay, let's walk through this question one step at a time. The goal of a recording system is to start from who owns it now and trace it back in the grantee index one layer at a time. See, who did he get it from? Who did he get it from? Who did he get it from? Okay? How far back do you go? Depends how thorough you want to be. Some people say go back 100 years. Some people say go 200 years. Or some people say actually go to patent, right? When did Texas gain the land from, Louisiana or France or Mexico, whenever it is? If you ever deal with oil and gas interests, they do go back to patent. They go back by 300 years. So you have a lot of searching. And this is what title searchings look like. Okay? So the example begins, says, a man named Dubeck is selling your plot of land. And in case you haven't noticed this, in law school, all the questions always have names in alphabetical order, like Abel and Baker and Cotter and Dubeck. Everyone notice that? We do that to make it easy for you. So you can just write A, B, C, and D in your notes. You don't have to write the full names. And I promise in my exam, all the names will be in alphabetical order to make it nice and easy for you. Just one less thing you have to remember and think about. Okay? So Dubeck is trying to sell you a piece of land. Okay? So Clement, if Dubeck is selling you a piece of land, what are you trying to figure out? What's your goal?
He has valid title to be able to sell it.
Okay, how would you know if Dubeck has valid title? Before you get to the books, how would you know if Dubeck has valid title? What would have had to happen previously?
He had to obtain it from someone else.
Someone else, right? Someone else. Who's that someone else? Do you know who that is? Okay. You don't know where Dubeck got it from. And assume he's a liar, right? Assume he says, oh yeah, I bought it from Joe Schmo. Lie. You need to check where did Dubeck receive it from, right? So how would you check where Dubeck received it from? Which one?
Grantor. Grantee.
Which one? Think about it. What are you trying? Whose name do you know here?
Too bad.
In the previous transaction, was Dubeck the grantor or the grantee? Grantee. Ah, everyone see that? In the previous transaction, whenever that happened, Dubeck was the grantee. Do we know the name of the grantor is? So which book are we looking at? Yes. You start with the grantee book. The reason why you start the grantee book is the only name you have is Dubeck. That's the only name you have. Everyone see that? Stop me if you don't, because it gets worse after this. Everyone see that? You start with the grantee index. That's what the present. Who received it? Okay? So, and kind of the answer was up here, but that's okay. Right? So we see that you start with the grantee index, and you find Dubeck's name. Right? Then what do? Tim? After you find Dubeck's name, or let me ask another one. How do you go about finding Dubeck's name in this huge book? Let's go back to this picture of the book. It's a huge book. I mean, it's humongous. How are you supposed to find his name?
Alphabetical.
Oh, you wish. You wish it was alphabetical.
Well,
how do you think they're recorded? In what order?
Track.
No, we're not in the tract index. It's the grantor grantee index.
Date.
It's gonna have to have date.
Which is it? Doesn't Derek? You might be wrong. How are they sorted? Go look at this diagram, right? Think about it. Before computers, right? There were no computers back then. There's an actual literal book. Tim, in what order do people write their names in the book?
It's like date.
You write them in the order they come into the office, right? This guy comes in on the first of the month, you write his name. This guy comes in the second of the month, you write his name. She comes in the third of the month, you write her name. All of the names are listed by date. In fact, usually each of these books was for a specific period of time, maybe January through May. And there was another book, May through December, right? So I'll ask again, Tim. Tim, how would you find Dubeck's name? What would you have to actually do?
Find out whenever you purchased it.
You don't know that. All you know is that he owns it today. That's all you know.
Can't ask him.
Nope, assume he's lying. I'm serious. You presume they're lying. You got to go to public records. If you have the book and you know he owns it today in the year 2014, how do you figure out when he got it? Yeah. One by one. You don't know if he bought it yesterday, a week ago, a month ago, 20 years ago, or 50 years ago. I'm serious. You go through this book, line by line, looking, Dubeck, no, Dubeck, no, Dubeck, no. You look through every single line going back however many years. This can take a long time. You have to go through many dusty books. Yes, Zoe? Well, they're awesome. Most places don't. Okay? But you need to, yeah, I agree. They're online. It's great. But you need to have this actually works. A lot of places, especially when you get to older deeds, are not digitized. Right? Okay? So you basically start the present time. You start in 2014, and you go year after year after year to hit 1977. So you're going almost 37 years, right? Right? Then what? Trey, what happens when you hit 1977? What happens? What do you find?
We would find the guy who sold the property to.
Dubeck.
Yeah.
Can you read that? Or, yeah. So what do you find? You can look in your book. It's on the same thing.
Okay.
It's 648.
Yeah, Cotter.
Okay.
1977.
No shocker. The person who sold it to D was C. No surprises there. Okay. So in the 1977, we find that the grantee was Dubeck. And Trey, who was the grantor? 1977.
Cotter.
Everyone see that. In 1977, Cotter sold it to Dubeck. Welcome back, right? Not enough people left. Cotter, remember Welcome Back, Cotter? No one watched Nick at Night. Okay. In 1977, Cotter sold it to Dubeck. All right, everyone with me? Okay, so now we have a new name, right? We know that as of 1977, Cotter owned the land. Joseph, now that we know that Cotter was the grantor in 1977, What happens next?
We have to find out who Cotter bought it from.
Exactly. And how do we find that?
I guess you go back through the continuation. You find out that Cotter bought it from Baker.
Which book are we looking? The grantor or the grantee index?
Everything in the grantor.
No.
Grantee.
Tell me why.
Because Cotter was the grantee from
Yes.
Baker Parker.
Yes. We don't know Barker's name yet. All we know is that Cotter. We know at some point Cotter got it from someone, maybe. So we continue through the grantee index, going year by year, 1977, 1976, 1970, blah, 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 all the way. We get to 1952, right? And then, Angela, what happens in 1952? What do we find? Okay, who sold it to Barker? I mean, Barker, I said it, yeah. So Barker sold it to Cotter, right? Everyone see that? So you keep going back year by year. So 1952, we know that Barker sold it to Cotter. Anyone else see it? Are you shaking your head?
No.
You shook your head. Okay, everyone see that? Barker sold to Cotter in 1952. All right, Garrett? So after Barker sells it to Cotter in 1952, what do we do then?
We would stay in the grantee index.
That's right.
Continue to look backward from Barker to see who granted it.
Exactly. So then we start going through the grantee index and looking, where was Barker a grantee? And then finally, eventually, we find who Barker got it from and whatever year. Okay. So let's say we go back to the year 1900. Right? That's as far back as we go. We go back to 1900. Right? You ready? Shamira? Shamira? You got it? Page 648?
Sure.
Okay. What happens when we find the original owner? Okay. Oliver. In the year 1900. That's as far back as it goes. What happens next? What happened? What do you do after you find that the original owner was Oliver? You got it? Is that a yes or no?
Yes, I mean, what do you mean after finding what?
All right, Mariah. What happens once we get back to Oliver in the year 1900? What do we do once we find the original owner? We go back 100 years. What happens next? Exactly. Okay, this is the move. If we say we're going back 100 years, right? We go back to the root of the title. You can go back 100 years, whatever. Once you go back 100 years to 1900, we know the original grantor, right? The original grantor is Oliver. Oh, original. Law professors are not very creative. Okay, so the original grantor is Oliver. Okay, so now we have O as the original grantor. Stephanie, what happens next? What's our next move? In which book? Yes. We now know the name of the original grantor. The original name of the grantor was Oliver. So we go 1900, 1901, 1902, all the way until we find in 1915 that Oliver gave it to Anderson. Shocking. A, right? So then we find it in 1915. Okay? Once we hit Anderson's name in 1915, we know Anderson owns it outright. Okay? So, Brooke, what happens once we know about Anderson? What are we trying to find next? Okay, good. And then, so what happens? We go 1916, 17, 18. What happens with 1934? Good. And then what happens in 1934? Read it right there. What happened in 1934? What happened?
It was sold to Barker.
Okay, but let's be precise. If you look at the index in 1934, what would you find? Good. Why would you see nothing in 1934? Everyone see that. Until something's recorded, it hasn't happened yet for our purposes. You only know about something happening after it's been recorded. So you look in 1915, 16, 17, 18, etc. You look 1934, nothing. Anderson still owns it. 1935, Anderson still owns it. 37, 38, Anderson still owns it. When you get to 1939, you see, wait a minute, Anderson sold to Barker 5 years ago. So between 1934 and 1939, there was a doubt, right? On paper, Anderson still owned it, according to the books. But in reality, Anderson had already sold it. Your boy Barker was 5 years late getting to the records office. The problem arises of what happens if Anderson was a jerk, and they're all jerks, and that 5-year window he sold to someone else. Had that person gone and done a title search, they wouldn't have found any record of this transaction. Until you record a deed, there's no notice about it. Everyone see that? So that 5-year window is where the problem is. So eventually, he recorded in 1939. Okay? Yes, sir?
I'm a little confused on the same transaction gets recorded in both of the books, correct?
Yes, sir.
Correct? Why are we recording them in two separate books?
The way we trace it is by going back from the present and up to the future.
Right.
So let me ask you this way. When you first started this entire endeavor, what was the only name you knew? D, right?
Right, D.
What other name could you have possibly searched for? Okay, so you have to start with the grantee.
Sure.
But then you have to go forward because you have to see, is the person selling it actually selling it to multiple people? Right? It's possible that the same person might be selling it to multiple times. The only way to do this is having separate for grantor and grantee index. Everything has to be recorded.
So that when you're recording the transaction in the grantee book, if they sold them to multiple people, that name wouldn't come up?
It would if everyone recorded. But there's no guarantee that both parties record. Right? Perhaps the first person who sold to record, but the second one doesn't. This is a way of preventing fraud. By having every party be required to record, it ensures that the most complete record is painted. Right? Say, for example, the grantee never records, but the grantor does. Right? And say there are several sales in the grantor. There's potential for fraud there. Shemaya, was your hand up?
I know they do it online now, like you can check to see like the title history.
Well, yeah, now it's online, yes.
Why would there be the same grantor or grantee with the same property twice, listed with different dates?
The transaction's recorded twice in both books.
Oh, so one would be the grantor's?
Yes, if you saw before, we have two different ledgers. One is the grantee, grantor, and you have a second book where it's flipped. The same transaction is recorded in both books, and this allows you to go from the present time back to the original, and then up again. I don't get that. Yeah?
Doesn't that make more sense, like grantor-grantee books separate if they're both in alphabetical order, though?
Who's making this in alphabetical order? Who's manually recut type?
It looks like it's not that.
It's not. They're not. You wish so in alphabetical order. Now, if someone goes back, this is literally a ledger book sitting in an office, and someone came in, and my name is like Xylophone or something. I put my name in first, and then like Apple comes in. Apple puts his name second. Unless they republish them in a very clean form, maybe they'll be alphabetized, but generally they're done by date. And not just date, time of day also. If you come in the morning, someone else comes in the afternoon, you may not have seen what happened in the afternoon if you come in first. Right? This is before the internet. There was no electronic records. That didn't exist for much of recorded history. I saw a couple other hands. Questions? All right. So everyone get the general gist. The reason why recording is important is, if you go back to the book, between the years of 1934 and 1939, this is where recording promptly becomes very significant. Between the years of 1934 and 1939, according to the books, Anderson still owned it. It was still Anderson's. There's no record of Barker getting it until 1939. So had Anderson been a fraud and sold to many people at once in this period, there would be a conflict, right? There will be a conflict between the first buyer and the second buyer. Okay. Before we get too far, turn to page 651. I love this story. It's one of my favorites in the book. Anyone from Louisiana? Anyone want to read this from Louisiana? Go for it. Yeah, read this. So the setup here, and I'll give a little bit of a background first.
I mean, I was familiar with Louisiana in general.
Have you been there?
Yeah.
Okay, that's good enough. So here's the setup. There's a lawyer in New Orleans was trying to do a title search back to 1803. And his lawyer said, you know, go back all the way as far back as you can go. Okay, so read this out loud, please.
The letter?
Yeah, it says gentleman.
I am in receipt of your letter of the 5th of this month inquiring as to the state of the title prior to the year 1803. Please be advised that in the year 1803, the United States of America acquired the territory of Louisiana from the Republic of France by purchase.
Okay, that's Louisiana Purchase, right, with our boy Tom Jefferson. All right, keep going.
The Republic of France previously acquired the title from the Spanish crown by conquest.
Remember we did the Johnson versus McIntosh case last year with the conquest, acquisition by conquest? Remember that? Okay, keep going.
Spain acquired title by virtue of discovery.
Remember acquisition by discovery, discovering the New World? Did you read this last semester? Good. Keep reading. I like it.
One Christopher Columbus, a Genesee sailor who had been duly authorized to embark upon his voyage of discovery by Isabella, Queen of Spain.
Okay, keep going.
For granting such authority, Isabella, a pious and cautious woman, attained the sanction of His Holiness the Pope. The Pope is the victor on earth of Jesus Christ, the only Son, heir apparent of God. God made Louisiana.
Okay. And I'm sure there's some Louisianans who probably would agree with that, God's country and all. But I think this story is very helpful to illustrate a point, right? When I say we go back to 1900s to find the original owner, it's something of a misleading idea. Land has been around for a long time, and hope I don't offend anyone, it's been around for billions of years, right? It's been around for a really long time, our land, okay? And at various points, different people have owned the land. Now, in this book, or in this description, there's something missing, Heath. What did you notice missing this entire point between the Pope and Christ and Isabella of Spain? What's omitting from that discussion? Yes, Native Americans, Indians, right? They are neglected from this history, and this is actually fairly accurate. If you did the Johnson versus McIntosh case last semester, you remember that under American law, the natives were not even allowed to contract to sell land. So they have no role of ownership in this chain of title. So anytime we do any kind of title search in the United States, we effectively have to go back no further than 1492 and then say hopscotch over to Christ, who created everything, or something like that. All right, any questions on that? All right, let's go back. So Lamar, let's go back and let's do the Luthi case. Luthi v. Evans. Now, the facts of this case are more complicated than they need to be, but at a very high level, what was the problem here?
So, I guess Luthi or Owens owned a bunch of interest in oil and gas leases. That he assigned to international tours, and then in the assignment it said it included all interest of whatever some nature in all working interests and royalty, whatever.
Okay, good. That's a good start. All right, so, and again, this is not too important for you to know, but it's good for the back of your mind. Again, when you sell a piece of land, you have your surface rights and your subsurface rights, everything underneath. So you can even own your house on top of it, but you can actually sell the rights to the oil or minerals, whatever finds underneath the ground. You can sell those separately. So in this case, Miss Grace, transferred a certain number of pieces of oil rights in her home. But she also put this clause in the contract, and it effectively says that in addition to whatever specific pieces of land I list in this contract, I also convey all interests that I own in Coffee County, Kansas, whether or not they're listed. Okay? So regardless of whether or not she listed these specific pieces of land in her grant, she's conveying them. Okay? This is what's sometimes called a Mother Hubbard clause. And if you remember the nursery rhyme, remember old Mother Hubbard, something in the cupboard? I can't remember the rest. You know the rhyme, right? I actually had a student a year or two ago came to me and says she was the only person at her office where she was interning who knew what a Mother Hubbard clause was. So this actually might be salient. But the purpose of an old Mother Hubbard clause is to say I'm giving everything I own whether or not I list it. Right? Everyone see that? All right. So Daniel, what's the problem with a Mother Hubbard clause with respect to the recording system? Why is this problematic?
It's very general. Covers everything.
Okay, good. But be more precise. Why is this not a good thing to have for purposes of the recording system?
Because the recording system lists everything specifically.
Yes. If you look up here, and I know the picture's a little blurry, when you record a deed for a piece of property, you have to be very precise. You have to say, here's the lot, these measurements, right? Why is it so important to be precise? Daniel? Other Daniel.
Because this is the only way that people know who,
Yes.
who people are.
Exactly. You need a precise recording system because it's the only way for other people to know who owns what. If you, for whatever reason, say a piece of property is, say, 50 meters or 50 yards long, and you say it's only 45 yards. Those additional 5 yards you're missing, no one will know who actually owns them. It creates very messy situations. So here, Ms. Grace specifically mentioned these 3 or so reserves, but she has this additional one, this Kufel reserves. And according to this old Mother Hubbard clause, she conveyed everything she owned. Right? Lee? Lee, what happens if you were doing a title search for the Kufel, right? This other one Grace owned. Would it show up anywhere in the books about that it's been sold?
No.
How come?
I guess because it's not known to the parties that it's not going to be recorded.
Exactly. If you don't specifically describe a piece of property that you're selling, it will not appear anywhere in the grantor or grantee books. The mere act of saying everything I own, that doesn't add a new line in the entry for each specific piece of property. So these Mother Hubbard clauses are problematic. I mean, they may be good. You can imagine a certain situation where a person's on their deathbed and they're about to die, and they're scratching off a will very quickly because they don't have enough time, and it says, you know what? I'm giving you all the property I own in the county. You can see that that might actually be a worthwhile thing to do. But in the context where sophisticated parties are selling mineral interests, where you might have competing claims to them, this doesn't make much sense, right? So, Nassim, what does the court do with this Mother Hubbard clause? Does the court say that's valid?
It does.
It is?
It is valid, but not in this case.
Okay, good. That's what Ansel's looking for. Is it valid in this case?
No, not.
Okay, you're right. Why is it not? Why is it not valid in this case?
Because Byers did not have actual notice or knowledge of the instrument.
Okay. The key point is these Mother Hubbard clauses do not provide notice to subsequent buyers. Right? The purpose of a recording system is all about giving proper notice. If you put one of these Mother Hubbard clauses in, there's no subsequent notice for everyone else. Right? There's no way for people to guess that maybe this Mother Hubbard clause exists and prevents the land from being transferred. You don't know anything about it. Okay. Now, Brittany, maybe they might say, well, why can't they just go dig up the contract and look for themselves? Why is that not an answer?
Probably because
Well, let me ask you this, Brittany. What actual documents recorded with the office? Is it the contract or the deed? Exactly. And what does the deed say on it?
who gets what. So
Right.
just because the contract is not recorded.
Exactly. Exactly right. Do you remember we did a few weeks ago, the contract of sale was this really long document with all these terms and stuff, and the deed was like a paragraph? The thing that's recorded in the office is basically a paragraph that says, A transfers to B, here's the lot, maybe here's the money being paid, and that's it. All the other terms, that won't be there. So it would actually even be impossible to expect the buyer to go dig up all these old contracts. It's not even a fair request. Everyone see that? So here the court says that this Mother Hubbard clause does not provide sufficient notice, and this conveyance was not recorded. So, too bad. Mother Hubbard clause doesn't work. Okay. Questions? Questions in this case? Okay. All right. So, and going back to Tim's question from before, he asked, well, what happens if they alphabetize them? Okay. Not only do they not alphabetize them, they don't spell check them, right? And this next case illustrates a problem when you have the name written incorrectly. So in the olden days, literally, you would have someone just write it in by hand. So in this case, the lawyer messed up. We'll get there in a second, right? But what happens, V? What happens if the person working in the clerk's office messes up? Say it's Elliot with 2 T's and they spell it with 1. And because the name wasn't written correctly, you don't have proper notice. Can you sue the government? Can you sue the clerk for messing up and screwing up your property? What do you think?
I would like to say yes, but it's not. But then you're kind of like out of luck at that point.
Yeah. What happens? The clerk writes your name wrong, as well, no one has noticed, and your property sold without your notice. Can you sue the government for negligence or something? No. Why not? Why not? As someone said it.
Immunity.
What's this immunity? It's not survivor.
Well, they're doing something as a government.
Okay, everyone know this. There's something called sovereign immunity. Learn this, because any type of government litigation, know it. Sovereign immunity. Sovereign like the king. Immunity means like you can't be harmed. Generally, when the government messes up, you can't sue them. If a government agent is acting within his discretion, you can't sue him. It comes from this old maxim that you can't sue the king without his consent. That applies today. You cannot go and sue the state of Texas. You cannot go and sue the governor. You can't sue the county clerk. Okay? There are narrow exceptions to the sovereign immunity doctrine. But if they misspell your name, tough nuggets. You're out of luck. You're out of luck. Everyone okay with that? Okay. But what happens if the lawyer sues the name? So, Jane, tell me, what happened in the this Orr v. Byers case?
So the plaintiff had the property and then he reported his name wrong.
Mm-hmm.
Spelled Elliot.
Good. Okay, so what was the actual spelling of his name?
The actual is E-L-L-I-O-T-T.
Okay, so the correct was E-L-L-I-O-T-T, okay? And then how was it spelled in the recorded deed?
Initially it was E-L-L-I-O, so it's one less.
Yeah, and then they spelled it a different way.
And they spelled it again with only one L and one T.
That's right. Okay, thank you. So the correct spelling of the guy, and I mean, Elliot's a fairly common name, right? The correct spelling here was Elliot with 2 L's and 2 T's. And it was also spelled with 2 L's and 1 T. And then, just for good measure, they tried it with 1 L and 1 T. Both were incorrect. So they spelled it wrong twice. And as a result, by the way, lawyers, this is how you get in trouble for legal malpractice. If you negotiate the sale of a property and you fail to write the name correctly, you are now liable for a lot of damages. So it was mentioned in a footnote in this case. Anyone pick up on what happened in this case? In the footnote they mentioned? Yeah.
Didn't he say that it was or he sued his attorneys for malpractice, and then now the attorneys are the one suing in this case.
Basically. So here's what happened, right? The lawyer messed up or sued the lawyer for malpractice. So basically the lawyer paid out to Mr. Orr because the lawyer hoped to get some money from this case. Basically, the lawyer was trying to fill his own debts by litigating this case. It's kind of a weird situation. But the lawyer here messed up. He spelled it wrong. Okay? So, Ty, what happened as a result that the name was spelled wrong? What was the problem that arose?
I didn't get paid, right?
Well, I mean, the lawyer didn't get paid, but what was the property dispute?
I thought it was because he didn't get paid.
No.
His name was spelled wrong.
No. Oh, I mean, who didn't get paid? I think you're on the right track.
The guy that he owed him some money or something.
Morgan?
Someone wanted to buy the property, they bought it, it turned out that when they did a title search, nothing came like it.
That's right. Well, what was actually, if they had spelled the name correctly, what would they have found?
That, you know, the Elliot
Not that he had it.
Or he never had it.
No. Yeah.
That or had a judgment lien.
Good. What's a judgment lien? What does that mean?
I guess whenever you, I guess you're gonna have to pay someone at a later date when they sell.
Good. Secured interest. Okay. So here's what happened. Elliot owed Orr money. Elliot didn't pay up. So Orr went to court and said, "Hey, this guy owes me some money. I want to put a lien on his house." Right? What does that mean, putting a lien on his property? If he ever tries to sell it, the person buying it will find that there's this judgment hanging over it and know that he will now be liable for that lien. Just because you sell a piece of property with a lien on it, that doesn't just get rid of it. The next guys get stuck with it. So what happens? Elliot sells it. The guy does a title search, doesn't find the name. And he takes the house. But now Orr shows up and says, "Hey, now you owe me the money." The new buyer says, "Hey, wait a minute. I never saw anything about this. I know nothing about this." Right? So Joseph, did the subsequent buyer have notice about this judgment lien?
The court said no, because the name was misspelled, so he couldn't have known because he didn't show up in the index.
Okay, that's right. Had the name been spelled correctly, right, and the second buyer went through the book, said, "Oh, wait a minute. Oh, crap, Elliot, there's a judgment lien on this. I'm not buying this. I'm not touching this property. There's a lien on it." But because the name was not spelled correctly, there was no notice provided to check on it. Yeah.
But let's say that the name was spelled correctly, or the court ruled in their favor. The warranty, like the insurance that you buy.
Ah, okay. Now we're talking about title insurance, right? What's title insurance?
That basically says that you are getting a clear title without any judgment.
Or, okay, what happens if it's not?
I guess that they pay you for it.
Exactly. So if you ever buy a home, you need to get something called title insurance, which is what Adam just spoke about. Title insurance means that you hire a title company to professionally search through all those old dusty books and make sure that the person selling it to you actually owns it. Don't do it yourself, or maybe do it yourself for fun. But if you're actually buying a piece of land, hire a professional. I usually have like 1 or 2 students who do this for a living, but I guess none in this class. These people are trained, and they say, if we give you this title and it turns out to be not good, we'll actually pay you the value of the property. It's a form of insurance. So say, for example, in this case, they bought the house subject to the $50,000 lien. If they had title insurance, they would have just paid off the $50,000. I don't think title insurance was used in this case. If a title company had been used, they would have checked all the variants of Elliot. So I had a student last year who actually does this for a living, and she told me they had to check every single possible similar-sounding name. A couple letters here, a couple letters there. It's a very serious job to do a title search. You don't want to mess up. You don't want to buy a piece of land that someone else actually owns, and then your client's out of luck. So this is why you have to pay for title insurance. Okay? Yes, ma'am?
I have a question, but like in this case, even if you don't find it, like, they wouldn't be liable because the attorney was the one that made the mistake.
That's right. So in this case, they didn't make the lawyer search for all the different spellings, right? Why not, Daniela? Why didn't they make the lawyer search for all the different spellings in this case?
Because it's the thing that not. Are they saying like that there was just a lot of names and then not every name disclosed like corresponds to the actual person who is subject to the lien? Right.
Danielle, what would requiring the lawyer to search for all these different variants of names, what would that result in? Do you have it, Zuhi?
A lot of work.
Yeah, it's a lot of work, right? Imagine how much time it is to search through one book for the name Elliot. Then you search through the entire thing again for the second version of Elliot. Then you search through it again for the third version of Elliot. That's a lot of work. So what the court basically says is we're not going to put this burden, right? We're not going to put all this extra work on the lawyers. This is going to be the job of the person recording it. Because if you're recording a judgment lien, you have every effort to make sure it's done correctly so that everyone knows the lien exists. If you're an idiot and you spell the name Sucks to you. And that's kind of the holding of the case in a nutshell. Okay? Everyone see that? Everyone with me? Okay. So there's this doctrine which is mentioned in a book called item sonans, right? Which I don't think you'll ever hear ever again for the rest of your life, but item sonans, which basically means it sounds alike. So Elliot, Elliot, Elliot. It's the same name spelled 3 different ways, and they're the exact same pronunciation. This is like if you ever go to Google and you type something and spell wrong, Google's like, oh, did you mean this? Right, yeah, so they can figure out what you're trying to say. So now we have electronic records, and it's fairly easy to do a title search when you have different spellings. You can just do a wild card to search this way or that way. But with the books, this was very difficult. Okay, everyone see that? So if you are ever so fortunate to get a judgment lien, you need to spell the name correctly. That's not too tough. Okay. Everyone with me? Questions? Okay, let's move on. Let's do the recording statutes. I think it's on page, what is it, 667? The reason why we have recording statutes is so we can explain what happens when there's a conflict. Okay? And specifically, again, I'll say this as many times as I can, when you have the grantor and the grantee, between the two of them, there's no need to record. Between the grantor and the grantee, there's no need to record. Recording only matters when a third party comes into the picture. Okay? Now, the basis of the Recording Act only comes into play when 2 different people claim the same piece of land. Right? If I sell to Eric and Eric has it, done deal. Eric has it free and clear. You don't even need to use the recording statute. But if I sell it to Eric and I sell it to Artemio, I sell it to 2 different people. Now we have a problem. Now the law has to decide who gets it. And the way the law decides this is based on something called a Recording Act or Recording Statute. Okay? So the easiest one to remember is called race, the race statute. You know, like a race, whoever gets to the courthouse first wins. It's literally a race. The race statute says the party that records first, wins. So if I sell it to Eric first and I sell it to Artemio second, if Artemio's faster to the courthouse, it's his. Doesn't matter who I gave it to first under a race statute. So take a look. It says example number 2. It says, Alex, just read aloud, please. Example number 2 on that page.
O, owner of Blackacre, conveys Blackacre to A and does not record the deed. O subsequently conveys Blackacre to B for a valuable consideration.
Okay, just stop there. Almost every question we have will begin this way. The owner conveys it to A, and the first person doesn't record, right? Alex, let me stop you there. If the first person records, what happens then? Easy. If the first person records, end the ball game. He wins. There's no dispute. But what happens next, Alex? Yeah, keep reading, please.
B actually knows of the deed to A. B records the deed from B under the race statute. B prevails.
Don't get that far. Okay. The problem arises when you convey to A and he doesn't record, and you also convey to B and B records first. In other words, this only matters when the subsequent buyer records first. Now, Alex, before we get to the answer, as a matter of fairness, I sold it to Eric first, I sold it to Artemio second. Artemio's faster to the courthouse. As a matter of fairness, who should get it?
Well, it depends if Artemio knows whether or not. If we're talking about fairness, it depends if Artemio knows who already sold it.
Let's say he has no clue. He has no idea what happened.
Then I think the race statute is fair that Artemio should get it.
Okay, and let's say Artemio is a little more crafty, and he's aware they gave it to Eric the day before.
If we're talking about equity, then
Okay. So under the race statute, we don't look at state of mind. Artemio gets it no matter what. The race statute does not reward fairness or equity, the word that Alex used. The race statute literally rewards speed. Who is the quickest? Right? It's easy. Who recorded it first, right? You look at the book, date and time, not alphabetical. Date and time, right? Who recorded it first? Done. Piece of cake. This has the virtue of efficiency, but it's very much unfair. Because, say, for example, Artemio bought it knowing it was already sold. Eric's, unfortunately, my friend, you're left out in the cold. No house.
And it's even if you knew.
Doesn't matter. State of mind with the race statute's irrelevant. So it's a very harsh rule. The benefit, though, is it's easy. There's no dispute. Whoever recorded first, it's date and time stamp, piece of cake. Currently, this rule is only in effect in Louisiana and North Carolina. So you have, barely any states that use this. Unless you're in Louisiana, then you have to run very fast to the court. Okay, questions about that? The more common one, and the one we have here in our great state of Texas, is what's called the notice statute. Okay? Here's an example. I'll show you later. Okay? The notice statute, again, deals with subsequent purchasers. And again, it's always the case where the first buyer doesn't record and the second buyer does record. Right? So I gave it to Eric, Eric records. I'm sorry, I give it to Eric, he doesn't record. I give it to Artemio, he does record. The difference here is it looks at state of mind. Right? If Artemio knew that Eric had it first, Artemio will not win. If the subsequent buyer had notice that there was a previous buyer, the subsequent buyer will not win. In other words, even though Artemio recorded first, because he knew about the previous deed to Eric, he has unclean hands. He will not win. Everyone see that? This format is a little bit more fair because it doesn't reward Artemio if he knew about the previous sale, right? But this is a lot more difficult to figure out. Cough drop. But it's a lot more difficult to figure out because there's burden of proof, right? How do we show an Artemio learned about Eric's deed? Artemio, not to slight you, but usually people have an incentive to lie in these cases because, like, oh, I didn't know about that. I had no idea. I don't notice. Because the only way that you win is by playing dumb, right? So a buyer has every incentive to play dumb and say, I had no idea. So you actually have to have lawyers introduce evidence saying, oh, wait a minute. I have testimony that so-and-so told him about this deed, or maybe he knew about it. Okay? Yes?
So even with the race statute, like if they went insane and were incapable of getting to the record to record, like nothing would stop that.
Repeat your question?
If they, under the race statute, like if A was like bought the deed and before he recorded, he went crazy. He wouldn't be protected.
Nope. Nope. Let's take a look at question number 3. Stephen, read example number 3, please. Read it. Don't read the answer. Read to the last sentence.
All right. O, the owner of Black Acre, conveys Black Acre to A, who does not record the deed.
Okay. So always O conveys to A doesn't record. Okay. Now what happens next?
O subsequently conveys Black Acre to B for valuable consideration.
Okay. So the key question under the notice statute is, did the subsequent buyer have notice of the previous transaction? Steve, in this case, was there previous notice?
It was not.
How do we know that?
There was no recording.
Oh, no, not just recording. It's always not going to be recorded. We're talking about additional notice, like someone told you about it. That's the key.
You got nothing with that.
Okay. This is not just Artemio looking in the books. This is someone told him, Tim said, hey, Artemio, you see that Eric bought it yesterday, right? The notice has to do with something outside the records. Okay? So in this case, Stephen, you're correct. B has no knowledge. And what happens, Stephen, when B has no knowledge?
B can be bona fide.
Yes, B is what's called, and you said the magic word, a bona fide purchaser. BFP. You might have seen that word before. Yes, you can call it BFP. That's fine. Not BFF. BFP. Right? You're a bona fide purchaser. You bought it on good merit with no notice of the previous transaction to Eric. Okay? Okay. Again, the difficulty of this statute is whether a person had notice. Did someone tell him? Maybe he should have known. Maybe there's some evidence in the record books that put him on notice. Right? These are downsides. It's a lot of factually intensive questions. Okay? Questions on that one? Yes, sir.
Is it subjective at all? Because you just said, should he have known?
Oh, we'll get there in a few minutes. So, but I'll give you a preview. Generally, there's two types of notice. Actual notice and our favorite, constructive notice. Right? And Alex, because you asked, I'll fire back at you. What do you think the difference between actual notice and constructive notice?
Well, actual notice, he actually heard of the property being sold.
Yeah, someone told him about it, right? What's constructive notice?
Should have known, maybe neighbor.
Yeah. Yeah. Let me give you a good example, right? If you're Artemio, right, and you see Eric living there, and you know he hasn't recorded, that might be a good sign that maybe he actually owns it. Perhaps. So there is actual notice and constructive notice. But we'll do that in detail in a couple more minutes. And just for completeness, I think I mentioned this, but again, Texas has a notice statute that's fairly, where is it? Here. That's fairly straightforward. So you have to have notice of the title. Okay? And there's always a constructive notice that's implied by the courts. Okay? Any questions on notice statute? Okay, the last one is the most complicated one of all, which is in a number of states like California and New York, which is called the race notice. And let me write this out because it's this horrible hybrid of race and notice, and it's a little tricky. So the subsequent purchaser is protected against prior unrecorded instruments only if subsequent purchaser, I told you this was a little tricky. There's two things that have to happen. Without notice of prior instrument, I'll read it again in a second. Records before prior instrument is recorded. Okay, so let me explain this. Now that's up there. With the notice statute, it doesn't matter whether or not Eric records. If Artemio knew about it, Eric wins. Here it's a little bit different. In this case, the only way that Artemio wins, if he, number one, he had no notice, and he records first. In other words, two things have to happen. He can't have notice, and he has to record first. Going back to the previous example, let's try this one. Let's say Eric bought it first, didn't record. Artemio bought it second, he didn't record. Neither of them recorded. Under a notice statute, who wins? David, what do you think? Under a notice statute, neither of them record. Who wins?
The person who nobody wins.
Someone has to win.
Wait a minute. Can you say
Sure. Eric's the first buyer. He doesn't record. Artemio is a second buyer. He doesn't record. Between the two of them, who wins?
The first buyer. Because the second buyer didn't know. Oh, no, the second buyer would win because
Why?
the first buyer didn't know.
And
the second buyer didn't know. He's a bona fide purchaser.
you're in the right ballpark. Again, we're under a notice statute right now, right? I sell it to Eric first, he doesn't record. I sell it to Artemio, he doesn't record. What is Claire? What's Artemio's claim?
That he was the first purchaser.
No, not Artemio, not Eric.
Then he was the second. They didn't have knowledge of the first purchase.
Yes. Does it matter if you record it or not under a notice statute? That's correct. Under the notice statute, the subsequent buyer does not need to record. Neither of them have to record. The mere fact that Artemio had it second and he had no notice means he gets it. I want to see that. Stop me if you don't. Yeah.
So what happens if there's a third purchaser?
And he then records?
Yeah, and then he records.
Then he gets it.
Okay.
But the example I'm giving him, the two of them, neither of them recorded.
Okay, but what if the third purchaser doesn't record it? Then
Same rules apply. The third subsequent buyer will get it. So everyone gets that. With the notice statute, neither party needs to record.
So does this happen often? People just sell the same thing multiple
In my final exam questions, yes.
times?
And in fact, I'm promising you, there'll be someone who sells something in the exam who does not own it and sells to several people. I promise you, they'll be on the exam. Take it to the bank. Does this happen often? Not too often, but it does happen enough that it's an important topic to review on, because if you mess up the recording system, people will start selling land they don't own. Okay? Yeah.
Is the policy behind giving it to the subsequent owner who has no notice to punish, in effect, the fault of Eric for not reporting?
What do you think?
Yes.
Okay. So there are a couple purposes why we have this policy of rewarding the subsequent buyer. One of which is punish the person who didn't record, right? The person who was lazy and didn't record. Okay? But also, it promotes certainty. We don't like kicking people off their land. So if Artemio is living there now, and all of a sudden Eric pops up out of nowhere and says, hey, that's mine, we want to reward the person who's on the land. This is actually similar to adverse possession. If someone's been on the land for a while, even though he's at fault because he was squatting, we'll reward him with it.
So if Artemio was on the land, even though he didn't report, and then Eric bought it second, he would have that constructive notice.
Yes. Yes, if you see someone living in the land, that's pretty good constructive notice that the person owns it. Right? Okay, so that's notice. But let's go back. Let's go now to the race notice. The reason why race notice is different is not only must Artemio not have any notice, he also has to record first. So again, situation, I sell it to Eric, Eric doesn't record. I sell it to Artemio, he has no notice, and he records first. He wins. He wins under the race notice statute. Now, okay? Shmear?
But he has to actually go look at the property. Like what if he just was gonna go all in and didn't decide to look at the property until he was going there and saw it? Like, do you have to have seen the property before?
Doesn't matter if you see. You have to record it with the county. I don't understand your question.
If Eric is a subsequent buyer.
Eric's the first buyer. No. Eric's the first buyer.
Artemio is the second buyer.
Yeah.
And you're saying he has to have notice before he buys the property?
No. Artemio can't have notice. If Artemio has notice and he can't take advantage of the recording statute, he loses. Once Artemio knows about Eric wins.
So if Eric's already on the property, Artemio buys the property without looking at the property.
No, that doesn't. It doesn't matter whether he looks at it or not. Does he have notice? If he has notice or should have notice, and then he's not, then he can't take advantage of the statute. Right? If for whatever reason Artemio knows Eric was a previous buyer, whether or not he's living there, if Artemio knows Eric was a previous buyer, then he strikes that at step one.
Before he buys.
No, he buys it anyway. But he can't take advantage of the recording statute. In other words, generally speaking, the subsequent buyer will have a better claim under this, as long as he has no notice. Artemio has notice, so he can't win over him. Let's do an example. Example 4 on the page 668. Where was I up to? Michelle, read example 4, please. Don't read the answer. Stop forget the answer.
O, owner of Blackacre, conveys Blackacre to A, who does not record the deed.
Okay, so O gives it to A, doesn't record. That's like I give it to Eric, Eric doesn't record, right? Okay, keep reading, please.
O subsequently conveys Blackacre to B, who does not know of A's deed.
Okay, very good. Okay, so that's the same thing that I convey to Artemio. Artemio doesn't know. Okay? What happens then?
Then A records.
Okay, so here's the facts. It's a little bit different, right? I give it to Eric, he doesn't know. I give it to Artemio, Artemio doesn't know. But then Eric records first. Who prevails here, Michelle?
Eric.
Okay, how come?
Because even though Artemio didn't have notice, he didn't record first. And Artemio recorded before him.
Exactly right. Under a race notice statute, both things need to happen. You need to have no notice, and you need to record first. So even though Artemio had no notice, if Eric records first, he wins. Yes, sir.
If neither of them record, then the subsequent purchaser wins.
If neither records, then yeah, the subsequent purchaser will win. Yes, that's right. Okay, yes?
Is there a certain statute of limitations that the first buyer has? Like say, so neither one of them go and then 8 or 10 years down the road, they don't crack on them report that deed.
The answer is actually no. There's no limitation when you can record the deed. And I think we'll see this in the last case for today where like you can wait 15, 20 years to record. So the answer is basically not. Right? Let's do some of the questions on page 669. And this might help. Okay. Kelsey, read question number 1, please, on 669.
Blackacre to A, who does not report. O subsequently dies, leaving H as her heir. H then conveys Blackacre to B, who records. B purchases for a valuable consideration and without notice of the deed from O to A, who prevails.
Okay, good. All right, so here's what happened. Again, O conveys to Blackacre, I give it to Eric, Eric doesn't record, right? And then O dies, leaving H as the heir, okay? Then H conveys it to B, who records, right? B purchased for a valuable consideration, right? Who do you think wins here? O? Sorry, who do you think wins here? Why do you think it's B?
Because he recorded. Oh, wait. He recorded it and he didn't have notice of the deed.
Okay, that's right. B prevails, right? The reason why B prevails is we want to reward the subsequent buyer who took without notice, right? B took without any notice there was any dispute over the land. Even though A didn't record, B can still take it. Okay? Let's try question number 2. Zach?
Yes.
Go for question 2, please.
O conveys Blackacre to A, not record. O subsequently conveys B, and gets the valuable consideration, but does not record. A then records and conveys to C, C purchases and conveys valuable consideration. B records, C records. Who prevails in the notice
Okay.
statute?
Okay, stop right there. All right, so first let's do this as notice, okay? This is a good question. Okay. O conveys to A. Again, I give to Eric. Eric does not record, right? I also convey it to Artemio, and Artemio doesn't record. Now it gets a little messy, okay? Eric records and sells it to C, okay? So at this point, C is a good faith buyer, right? C bought it without any notice of anything happening, okay? Then B records. Then C records. Okay, let's do this one step at a time, Zach. Zach, between A and B, who has the better claim? That's right. Why? Good. Okay. So between A and B, B is a subsequent buyer for value without any notice. So we reward B. Okay. What about C and B?
I would say C for the same.
How come?
Because he had no notice of the subsequent purchaser after.
That's right. C is a subsequent buyer for value without notice. Okay. So in this case, Eric, who wins in the very end? That's right. C wins. Sucks to be, right? Right. Even though B necessarily wasn't at fault, C wins under the notice statute because when C bought, he did not have any notice of what happened before. Okay. Everyone see that? A little tricky, but not too bad.
Even if it's already reported.
With a notice one, it doesn't matter. Now the next one, let's do the race notice, right? Andrew? So, okay, so let's talk about this with the race notice, right? What are the two requirements on the race notice that have to happen for the subsequent buyer? Good. So first one is no notice, right? What about the second one? Okay. With a race notice, you need to first have no notice, and second, you need to be the first to record, right?
So I think
between A and B, let's go one step at a time, right? Who records first?
A.
Okay, so A records first. Okay? So between A and B, who wins on a race notice statute?
A.
That's right. Okay? Can A convey title to C then? Okay, so A can convey title to C. Okay? Then what happens? Can C, what happens then? Can C, who wins, C or B?
I think it would be B. Just because oh, no, it would be C because he bought it from A.
Right. B recorded first, right? And he had no notice. So actually the question changes a little bit. B wins here. I'm sorry. I said that wrong. I'm sorry, that wrong. No, you're right. You're right the first time. C wins. C wins, right? C prevails. Okay. Not too tricky. Yeah.
Doesn't B win because so C prevails in the sense that he doesn't have notice. But then B records first. So C doesn't record first. So then C fails the race part, and so B wins.
All right, let's walk through this one step at a time, okay? Because the race notice, it's a little bit tricky. So first, okay, we have. Okay, so O conveys to A who doesn't record.
Oh, so because A beats out B.
Exactly. That was why I first asked him, because A beat B, A can then give it to C, and then C is the correct owner.
That's just because A wasn't correct.
Yes.
So B was out initially once A beat him out.
Pretty much, yeah.
Okay.
That's why it's different than the previous one with notice. With notice, it doesn't matter whether the previous party recorded. Here, the initial recordation matters. Right? The fact that B recorded first, mattered. Okay. All right, that's a little tricky. Don't worry too much about that. Okay. All right.
Would you tell us like this is a race?
Yes, exactly. An exam, I'll tell you if it's race or race notice or notice. If you look at my exams the past couple of years, you'll see I think I've asked all three of them at various junctures. So be familiar with them. Yeah.
We're talking a lot about conveying. I wonder if it's the same with just flat out selling, and if it is, I think that question was up there. But what's the liability of the seller who's just going on the same piece of land?
I see what you're saying. So the question is, what's the liability for selling the same piece of land to three different people, right? Fraud, right? You can get sued for a lot of damages. All these questions have nothing to do with fraud. That's something you can sue on separately. If there's a general warranty deed, you can sue on that also. This is only about who owns the land. But yeah, you can sue for a lot of money for the fraudster who fraudulently missells the same piece of land. Yeah? Okay? All right. The last case is a little bit more complicated than it's worth. Someone's chuckling. But one of the key things about recording is that you need to actually have a notary sign or attest to it. Anyone ever got a notary done, or anyone a notary? Yeah, you're a notary. So what kind of like? Am I a notary? No, he raised his hand. Like, do you ever have a situation where like people ask you to sign stuff that you probably shouldn't, or like what did you have?
My sister and my mom would just like have something like notarize this. Just borrow your stamp. I'm like, I can't have my stamp first off. I got to record it in my book.
Right.
I won't do it to them anyway because it's family.
Right. So effectively, what happened was in this case there were a number of deeds being thrown around, and for whatever reason, in one of the deeds they used the phrase "and his heirs," and for whatever reason, the genius decided no, it's got to be "and her heirs." Okay, makes no difference, right? His, her, feminism, whatever. It makes no difference in the law. You consider them synonymous. So they ripped up the attestation. To a test, they ripped it up, and then they called the notary on the phone, right? And apparently the notary called the woman and said, "Hey, can I sign this?" She's like, "Yeah." Can you do that? Yeah. The reason why you have a notary is someone who's authorized by the state, who's supposed to be an honest person, has no reason to assume you're not, who will take an honest signature and say, yes, these two people here, they presented their identification, they agreed to this, and there's no elements of fraud, right? So what happens in the end is that the attestation was improper. So if you try to record a deed without the proper notarial seal on it, it's void. It's void from the beginning. So actually, if you go to page 676, you can cheat a little bit. There's a really good description of the case, which I should put up front. It's note 5, which is basically the entire case. So basically, O conveys to A who does not record. Okay. O conveys to B who has no notice. Okay. You enter B's deed into the records, but as a defective acknowledgement. Okay. Then B conveys to C who has no notice of A's deed. Okay. This is basically the case where a deed is not recorded because of the bad notary seal. And even if on the face the notary seal looks valid, because the signature was there, even though she has no recollection, maybe she didn't record in her book, you're not a purchaser in good faith when the first one was void. Now, this one's something of an unfair doctrine, because imagine you go to the records office, right, and you're flipping through the books, and you see the deeds recorded there. You have no reason to think that it's void. And it's only after the fact that they come back with this other evidence and they explain how it's no good. Yeah, that's the big takeaway from that case. Nothing too dense there. All right, questions? A little bit heavy today, but good. All right, no class on Wednesday. I will see you all on Monday, and have a nice Constitution Day. Hello.
Okay. My question is,
Anyone else not sign this?
I did.
Hey, real quick,
Yeah.
sorry.
Yeah.
I've got to do a case.